Islam, peace and love. I am Sade Renee L, all rights reserved, and I'm back at it again with another video. And thank you for tuning into my channel, Energy, Energy, Energy. And today I'm actually going to just be doing a quick video on case law. This is only a part one. I'm going to be doing more videos on constitutional case law because there's a lot to cover. So with that being said, thank you again for your time. Please like, share, subscribe, and leave a positive comment. A positive comment, excuse me. You hear that? Positive, you know what I'm saying? Not negative, to all the trolls. And with that being said, I'm just going to get straight to it. Again, thank you for your time. And here we go. City of Dallas versus Mitchell 245 S.W.944. An illegal arrest is an assault and battery. The person so attempted to be restrained of his liberty has the same right to use force in defending himself as he would in repelling any other assault and battery. You can see State versus Robinson as well, 145 ME 77,72 ATL.260. Stock versus Medical Examiners 94 CA2D 751. .211 P2D 289 in interest of MV 288 APP 3D 300 681 NE 2D 532 1st District 1997. And it reads, where a court's power to act is controlled by statute, the court is governed by the rules of limited jurisdiction. And courts exercising jurisdiction over such matters must proceed within the structures of the statute. The state citizen is immune from any and all government attacks and procedure absent contract. See Dred Scott versus Sanford 60 U.S. 19 HOW 393. Or as the Supreme Court has stated clearly, every man is independent of all laws, except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. Schuer versus Rhodes 416 U.S. 232. And it says, note, by law, a judge is a state officer. The judge then acts not as a judge, but as a private individual in his person. When a judge acts as a trespasser of the law, when a judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are voidable, but void, and of no legal force or effect. The U.S. Supreme Court stated, when a state officer acts under a state law in a matter violative of the federal Constitution, he comes into conflict with the superior authority of that Constitution, and he is in that case stripped of his official or representative character and is subjected in his person to the consequences of his individual conduct. The state has no power to impart to him any immunity from responsibility to the supreme authority of the United States. Donnelly versus DeCristoforo 1974, and McNally versus U.S. 483, U.S. 350, quoting U.S. versus Holzer 816, and it reads, fraud in its elementary common law sense of deceit includes the deliberate concealment of material information in a setting of fiduciary obligation. A public official is a fiduciary toward the public, and if he deliberately conceals material information from them, he is guilty of fraud. The law requires proof of jurisdiction to appear on the record of the administrative agency and all administrative proceedings. Hagens versus Lavin 415 U.S. 533. A judgment rendered by a court without personal jurisdiction over the defendant is void. It is a nullity. Shramick versus Shramick 17 Can APP, revised denied 252 KAN 1993, and it reads, the law provides that once state and federal jurisdiction has been challenged, it must be proven. Now we have here Maine versus Thibault 100 SCT 1980, And it says jurisdiction can be challenged at any time. And jurisdiction, once challenged, cannot be assumed and must be decided. And then we have here Basso versus Utah Power and Light Company, 395. And it also says, once challenged, jurisdiction cannot be assumed. It must be proved to exist. Davis versus Weschler, 263 U.S. 2224. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. We also have here Miranda versus Arizona, 384 U.S. 436491. The claim and exercise of a constitutional right cannot be converted into a crime. Then we have here Miller versus U.S. 230 F 486489. There can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. Then we also have here Miranda versus Arizona 384 U.S. And it also reads again, where rights secured by the Constitution are involved, there can be no rulemaking or legislation that would abrogate them. Then we also have here Norton versus Shelby County. An unconstitutional act is not a law. It confers no rights. It imposes no duties, affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Then we have here Scherer versus Cullen, 481, 1973. There can be no sanction or penalty imposed upon one because of his exercise of constitutional rights. And then we have here Simmons versus United States, 390, 1968. The claim and exercise of a constitutional right cannot be converted into a crime. A denial of them would be the denial of due process of law. Cooper versus Aaron, 358 U.S., 1958. Excuse me. It says, note, any judge who does not comply with his oath to the Constitution of the United States wars against that Constitution and engages in acts in violation of the supreme law of the land. The judge is engaged in acts of treason. The U.S. Supreme Court has stated that no state legislator or executive or judicial officer can war against the Constitution without violating his undertaking to support it. You can also see Sawyer 124, 188, and as you can see, the other case laws beneath it, excuse me. Brain freeze. All right, well, there you have it. I'm going to stop there for now. Once again, this is just a quick video on some constitutional case laws. And, don't forget to study well. My recommendation is to learn some case law that applies to you or any situations that you think you may encounter. Well, no, not let's say encounter, because we don't want to manifest that. Memorize case laws that might assist you, or, something that you think might help, or just things that you're interested in. But I always recommend that you do what's the word I'm looking for? Gosh, brain freeze. You memorize. Gosh, why was that so hard for me to recall? You memorize some case law studies. And with that being said, I also want to make a slight correction on one of my videos in regards to jurisdiction. I broke down juris, right, and then diction, meaning words. Jurisdiction also does mean law language. So I just wanted to clear that up because I think we're pushing more law language for the proper term and meaning of jurisdiction. And just to be clear, but I mean, jurisdiction has numerous definitions. So, take heed to them all. And with that being said, of course, study all things, and keep that which is good to you. Use your gift for discernment. And when you study all things, study yourself. And when we say study yourself, just don't sit and say, oh, well, who am I? Blah, blah, blah. Study yourself actually means taking in the spirituality work where you meditate, you take quiet time to yourself, you read daily affirmations, things of that nature. So make sure you study yourself. And more love in the air, more unity, more peace. Free baby Ashe. And until next time, thanks for your time and energy. Peace and love.